Good afternoon, good morning, and good evening to all who are out there. Welcome to another live stream here on the Ray Law International channel. My name is Anthony Ray. I'm one of the immigration attorneys here. Today, here on Juneteenth, we want to wish everyone a happy Juneteenth here in the U.S. And elsewhere, wherever you may be. Today, we're going to be talking about the O-1 visa, but 2 days ago, President Biden just issued an executive order, or at least hinted at issuing an executive order. We'll get to that near the end, but we're going to have to add that on. So as we go throughout today, over the next few minutes, this is your time to ask questions. Make sure that you ask your questions. You know, it may be employment-based immigration, it may be family-based immigration. Feel free, jump in, even though we have sort of an agenda laid out with the O-1 visa. And then at the end, we're going to talk about the Biden executive order. This is your time. We want to make sure that your questions are answered, and we want to take care of you. So, and we're here for you. So with that being said, let's jump into the O-1 visa. Now, for a lot of people, you may not have heard about the O-1 visa. So let me try to give you a background or description of what the O-1 visa is and how it is applied. So there's the O-1A visa. That's for people who have extraordinary ability in the science, arts, education, business, and athletics. And O-1B for those with TV and motion pictures. Today, TV and motion pictures, that's a whole nother area. We probably can spend another half hour to an hour discussing the details of that. We really just want to focus today on the O-1A, those individuals in the science, arts, education, business, or athletics. And as you can see from our description, we do have a great surprise for you coming up in about a week or two. We're going to be doing a video with someone who is preparing for the Olympics coming up in a couple months. And they're preparing, trying to get ready and qualify for the Olympics. While they're not representing the U.S. yet, we think it's going to be really interesting to get a perspective of those athletes, of how do they get the O-1, what are the requirements, what was his or her experience, and more importantly, what is it like training and preparing for the Olympics? So stay tuned. We should have that coming out in early July. So that'll be on our main YouTube channel. And we'll also try to post that in our LinkedIn as well as Facebook. So today we're going to talk about O-1 visas. And basically, this is for individuals who have extraordinary ability in the arts, science, business, or athletics. It is also available, as we talked about, to those in the TV or motion picture industry. There's a whole different requirement for them and what they have to prove, but we're going to just stick to the O-1A for now, okay? Now, let's move on to eligibility. And remember, oh, hold on just a second. There's a question in the chat by Martinez. Yes, we do EB3 sponsorships. We would love to talk to you. Basically, the way we do those consultations, you can always call in. We'll put our number on the screen, so you can call in, English or Spanish, doesn't matter, but we want you to be with your employer, okay? You have to have a U.S. employer. Unfortunately, we do not connect you with the U.S. employer. We don't find you work in the U.S. I know a lot of people would love that. There are many organizations out there on the internet that are legitimate and will help you find a job or connect with the U.S. employer. But yes, we do EB2s, EB3s all year round. And we're very familiar with that. Just a quick note on the EB3 for those who are not familiar, there's 3 subcategories. There's EB3 professionals, EB3 skilled and EB3 other workers. So Martinez, why don't you put that in the chat? Let us know which of those 3 subcategories you qualify for, and we'll keep that going. We're going to jump back to the O-1A, okay? Going on to eligibility criteria. The first is going to be extraordinary ability, okay? How do we show that? We have to show, or you have to demonstrate extraordinary ability by sustained national or international acclaim, okay? Within your own country or around the world, whatever it may be, we have to document that. We'll talk about how to support that requirement in just a minute. Let's talk about the documentation requirements. Next, extensive documentation showing your extraordinary ability and achievements. Whenever we meet with someone, we always ask for their CV and their history, their awards and everything, so we can get a snapshot of what they have accomplished, where they are going, and how they're going to qualify for this O-1 visa. Also, we get letters of recommendation from experts in the field. People who know you, people who can attest to your extraordinary ability. And remember, this is just not athletics, even though we're talking about sports and athletes right now. This also applies to business and education. We have some potential clients out in California that they all have O-1s, very bright, young, intelligent graduates who were educated here in the US, and they're starting businesses, entrepreneurs. So there's many options. You know, if an H-1B is not available, maybe the O-1 is a great alternative for you. So that's why you want to check with us to see if you qualify for that O-1. And then the third thing under documentation requirements is awards, publications, media coverage, or evidence of recognition. It's a funny note. I just want to put a plug in here. We'll probably get this on the next time we do a live stream. We're talking about media coverage, not really media, but we had the opportunity, or at least I had the opportunity and privilege to be on the 90 Day Fiancé. We'll share that somewhere in the chat or later on, so you can kind of see us in live action on that TV show. It's on TLC, 90 Day Fiancé. All right, guys. Martinez, you didn't respond. Let me know, what's your highest level of education? What's the position? So we can kind of guide and kind of dialogue a little bit. You know, what's the position? Let us know so we can kind of tell you whether you're going to be professional, skilled, or other workers. Okay? Next, evidence to support the O-1A petition. The first thing we want to look at, there's multiple ways. We're going to look at maybe about 6 or 7 here. Let's talk about those as we go along. The first one, as we mentioned, is awards and honors. Okay? We'll get to you in a second, Martinez. Thank you for posting that. Evidence of receipt of national or internationally recognized prizes or awards. You don't have to have a Pulitzer. You don't have to have one of the highest. Now, those are great if you do. Call us. Those are a lot more straightforward. Not easy, but more straightforward. And then the next one under that is examples included, as I just mentioned, Nobel Prize, Grammys, or significant industry-specific awards. So there's a lot out there. There's probably something very particular, specific to you. Maybe it's engineering, maybe it's environmental, maybe it's artistic, poetry. You know, there's many ways that you can prove that you qualify for the O-1. And the O-1's a great way to get to the US and work. So check it out. Before we move to the next one, which is membership, let's go to Martinez's response. He said, "Yes, my employer is good with the sponsorship. I think a fall in the skill category, since I'm in CDL driver, please provide me with the number for a consultation." All right, so I'll just post the number. It's on the screen, but I'll also type it in the chat so you have it. Go ahead, you can call now. Our receptionist is waiting and she'd be happy to schedule an appointment with you and your employer. But basically, you're going to fall into most likely either the EB3 skilled, if we're looking at 2 years of training, or or experience, or we can always do EB3 others. So either way, we're going to go through the process. The process does take time, but we'll get all into those details. That's a whole nother 30-minute presentation. So we want to set that aside and we'll get to that. Okay? All right. Thank you. Let's go back to our list. Hopefully I'm not lagging at all. But next, memberships. Evidence of membership in an association that requires outstanding achievements for membership. Now, we're not just talking about a membership where you just pay $100 and you're in. No, the membership or the association has to have certain requirements to get in, and those requirements have to be high, So there's many of those out there, especially in the science and business. Several organizations require, for example, that a person be working for at least 10 years, or if they're investments, that they've had over $100 million in an investment. So work with us. We'll work with you to see in your field what associations that are out there and how you can meet those to help meet the requirement or add to the evidence to support your requirement. Next, published materials. If you have published materials out there that you've created and it's noted in magazines, on the internet, wherever it may be, you want to include that as well. Published materials in a professional or major trade publications, or even major media about your work. Very important. I think back before, we used to we had an artist, I believe from Japan, and she was in many magazines in her home country, and it was great. She was working with wood, beautiful, beautiful design tables, and we used that in her articles from Japan, in addition to what she was doing here in the US, to put together an excellent petition for her to get the O-1. Okay, O-1. Now, what we aren't going to talk about today is the EB-1A, which is extraordinary ability for the green card. We'll have to touch base and talk about that next, but the O-1A is a good way to get here to work. Everyone always asks, well, how do I work? I got to make money, I got to pay the bills. This is the way to do that. After published materials, we have original contributions. This includes evidence of the individual's original scientific, scholarly, or business-related contributions of major significance to the field. Okay? So if you have this and it's published, make sure you include that. Next, authorship. Okay, go ahead and put authorship as as the next evidence on the screen. Authorship of a scholarly article or professional journals or other major media. Okay, all right. And then next, underneath that, judging or evaluating. Okay, just a second. So if you have had the opportunity to judge others' works or to evaluate it in a business context, there are many competitions around the world. If you're in that position, then this is one of the evidence that you can document that you've been asked to judge other people's work in your field. That kind of shows your expertise and your ability that you've risen above the actual norm. Okay? All right. So that goes over the requirements, some evidence to help do that. Let's talk about the process, the petition process. So in order to file, you're going to see that you're going to need to file a petition first here in the US. In the US, we file that with the USCIS. Okay, we'll be filing on Form I-129. Please note that things have changed since April 1st, the filing fees. We did another video on the filing fee changes, so be aware of that. There's additional filing fees. I was reading a listserv with other immigration attorneys, and one of the attorneys was frustrated that their case was returned, and part of that issue was the filing fee amounts and what filing fee amounts are required and what evidence you have to show whether you're 25 or fewer employees or 26 or more, and how that all impacts your fees. It's gotten more complicated, which is unfortunate for the system and the employer, but which means that you really need to rely on your attorney a lot more, and it's all the more important to have an attorney assist. Now, if you're coming on the O-1A, you're probably asking, what about my family? What about my kids? Can I bring them with me? Absolutely, you can bring them with you. You can bring family members. Go ahead and throw that up on the screen as well. Right after that, dependents. So you can bring family members and dependents along with you, spouses and children under the age of 21. Okay, so they're going to get the same period of time that the principal applicant has. So if you get 3 years for your initial period of time, then your spouse and children will also get their status for that period of time as well. So the way that this works is, first the principal will get the O-1A petition approved in the U.S. It'll be for 3 years. Then what they'll do is they'll get their O-1A visa abroad in their home country. Once they get that visa stamp in their passport, they can get it with their family there and they can all come in. Now, if the family is already here with the principal in a different category, such as a visitor or student, then we would change here in the United States by filing with the USCIS and change from their current status to O-1A and then the I believe it's O-4 for the dependents, okay? Finally, one thing that's also very unique is dual intent. What is dual intent? Dual intent means you can have an immigrant and a non-immigrant intent. What does that mean? The immigrant intent means permanency, that you want to stay here permanent. The non-immigrant intent means that you want to stay here temporarily. Now, the non-immigrant intent or temporary intent says we have to show that we're going to return back to our home country. Okay, and if you don't, then you want to stay here permanently. That's the immigrant intent. So certain visa categories has what we call dual intent. This allows the person to apply for a green card while still holding that non-immigrant visa category. It's a legal fiction that you can have two intents for certain visas, but you cannot have two intents for others. An example of a single intent visa categories are your F1s, your student visas, or your J1, your exchange visitors visa category. Examples of your dual intent are O-1, the one we're talking about right now, H-1Bs. H-1Bs are for professional positions or specialty occupation visa categories, or the L visas, which are intercompany transferees that we work with many employers on. So dual intent is an aspect of the O-1, which is excellent. So this is also another wonderful way to use it. So in summary for the O-1, before we jump over to what President Biden has thrown into the immigration mix, let's summarize. If you are an applicant with extraordinary ability in the science, business, arts, or athletics, you can qualify for an O-1. If you're training for the Olympics or other sports, reach out to us. We can help you. We've done this many times in the athletic area for athletes. Feel free to reach out to us. This is an excellent category for you and for your family. It makes life so much more easier to be in the U.S. instead of trying to fit into one of those other categories. Also, remember, you have to be a contributor to your field. If you don't meet this mark, think about ways that you can engage. We can help you, get into the associations, meet those requirements, do publication. It's so much easier to publish now these days. Get your publication out there, speak at certain events, become a speaker at various events to get your name out there. There are many ways to meet these requirements, or at least build up to them, so that you ultimately, meet them. And you can do this while you're in F1 or abroad. You want to build up your portfolio and your background so that it is extraordinary and meets the requirements. Now, this level of extraordinary is not way out there. It is something that is attainable. You don't have to have a Pulitzer Prize or a Grammy, okay? You can still get that O-1. Now, When we talk about the EB-1A, which is also extraordinary ability in this area for the green card, that standard is bumped up quite a bit, okay? And it can be a lot more challenging even for those who have accomplished quite a bit, okay? So again, just a quick note to everyone out there, if you have questions, any immigration questions, please post them in the chat, just like Dennis did regarding his questions about EB3s, okay? So post those, get in touch to us, let us know what your questions are out there. We're here to help and serve you guys and help you navigate this chaotic immigration system that is always throwing curveballs at us, which takes us to the next issue and topic, which is on June 17th, President Biden introduced an executive order. All right, so we're going to take a look at this real briefly. We're going to be doing a couple videos on this in more detail, but we just want to do a quick overview to give you guys a flavor for what we can, what you can expect from the Biden administration. Now, I'm going to give my own editorial comments about this. So, bear with me as we go through this. Let me see if I can make this bigger. You guys don't need to see me. We'll get this up on the screen here. Okay. All right, I think we're good. Keeping American families together. That's the thing. That's the theme. Now, it cannot go without saying that it is very unusual that we are essentially 4 to 5 months from an election and all of a sudden we have some wonderful positive immigration introduction. We're not going to talk about politics. However, politics always impacts immigration. I tell people often, immigration is that political football. I know it, you guys know it, every election cycle, immigration pops up, we all get very emotional about it, and it gets kicked around, but unfortunately at the end of the day, nothing happens. We still have, I don't know, you choose your number, 11 million plus, 14 million plus people here who are illegal. Our system is still outdated from, I don't know, the 1950s is what I typically tell people. So unfortunately, we have a broken system and it's just not working. So here's an executive order to sort of, and I don't even want to call this a Band-Aid. It's really just to also get that political discussion going. As you know, President Biden and Donald Trump have their debate coming up next week, so immigration may be one of those topics, and I think this is put forth in order to have some discussion. Now, as with many other executive orders, whether it was previously by Trump or by Biden on immigration issues, don't get too excited. The other side is always filing suits to put in an injunction, to put it on hold until some higher court makes a decision on the process. And as you know, with other immigration matters that have been presented like this, they usually don't go forward. However, let's remain optimistic and talk about what the administration is looking to do. So first, keeping families together. What they want to do is this process will help certain non-citizen spouses and children apply for lawful permanent residence status they already are eligible for without leaving the country. Now just want to comment, if they're already eligible for it, why do we have to add an additional process? This appears to add on yet another layer for our foreign nationals to go through, or another hoop to jump through. While it's okay for the attorneys because now we've got to figure this out, there's another immigration step before they actually apply for their green card. Generally speaking, people who are in this situation will have, if they're already eligible, then they should just go ahead and apply. So the language used here needs a lot more clarification, okay? Why do we need another step or process if they're already eligible? Now, it does say without leaving the U.S., there is an option for the 601A, where we talk about unlawful presence waiver. unlawful presence waiver. That's an option for people in a similar situation where they're here, but their only violation is that they overstayed their status. They can get a waiver approved and then move back in, okay? Let's move to the next one just to stay on time because I know everyone's busy, okay? The next one, these actions will promote family unity to strengthen our economy, providing significant benefit for the country and helping U.S. citizens and non-citizen family members stay together. So a lot of calls that we received yesterday and the day before, do I qualify? Well, you may, and most likely you will. The problem is that the administration has not provided any final rules and requirements for us to really, tell you or answer that. On the surface, yeah, you may qualify, but we have to wait for those details. And the details coming up next. Look at this. This is really interesting. In order to be eligible, non-citizens must, as of June 17, 2024, have resided in the United States for 10 or more years and be legally married to a U.S. citizen while satisfying all applicable legal requirements. On average, those who are eligible for this process have resided in the U.S. for 23 years. Now, one of the main things to note here is you have to be legally married. A lot of people that we interview or spoke with, they're not even married yet. And unfortunately, many of the people who are here unlawfully end up marrying people who are also here illegally. So if your spouse or your child is not a U.S. citizen, then it's going to be challenging to benefit from this. So that's why when we talk about the numbers, it's only 500,000, okay? And 50,000 children that may be impacted by this. It's a small portion of the bigger problem that we have. Remember, there's about 11 to 14 million people are here unlawfully. What are we going to do about the majority, the big elephant in the room? Let's continue. Those who are approved with the DHS's case-by-case assessment, this is that additional step. How are we going to get this assessment? What are the requirements for the assessment? And then there will be afforded a 3-year period to apply for permanent residency. What's happening? Their law hasn't changed, okay? This is where I think you're going to get a lot of kickback from the other side. How are they going to give these individuals green cards, permanent residency, if they can't do it now already? So we're going to see how the administration wiggles around this without getting Congress to do their job. They will be allowed to remain with their families in the United States and be eligible for work authorization for up to 3 years. This will apply to all married couples who are eligible. Again, there's that key word, marriage. They're really forcing everyone to make sure you're married. If you're not married or you're not really into that, well, you're going to lose out. And the problem with this is you already had to have been married from June 17th. That date has already passed. So even if you run out there today, you are not going to benefit from this, unfortunately. And then finally, this production will impact, as I mentioned, about 500,000 people and 50,000 non-citizen children under the age of 21. This raises another issue of what happens when or if they age out, meaning they turn 21. Does the time that the USCIS is adjudicating this application process, is that told? Is that extended for those children? There's going to be so much to look at and analyze and get answers to. This is just surface information, probably for the debate next week, because we have not seen the details. There's a lot of people giving us some information of what it could be, but until we see it in writing, it's going to be very difficult for us to say, do you really qualify? Now, easing the visa process for college graduates, including dreamers. So back in 2012, I believe, President Obama introduced DACA, Deferred Action for Childhood Arrivals, and that has been going on for 12 years. And even within those 12 years, Congress has not acted to resolve the issue, even for this small group, which also is about 600,000, 700,000 individuals, okay? Which is, remember, it's a small amount compared to the greater 11, 14 million people who are here illegally. It's not solving the problem. It sounds good. It's good for politics. It may be good for getting reelected or, not getting reelected, but it doesn't solve the problem. Congress, and I encourage everyone, that's the sad thing about this. This is sort of like that political football. It's not doing what it really needs to. It sounds good. It helps a small, minute category of individuals. But we're still left with how the number of people who are here do not have access to certain benefits. They pay into Social Security, but they don't get access to it. They don't have work permits. They're not in the system. And these are people who are already contributing to the system. People who are here, they're working with or without the work permit. People have to survive, so keeping that in mind. So President Obama introduced DACA in 2012. Today's announcement will allow individuals, including DACA recipients and other dreamers who have earned a degree at an accredited U.S. institution of higher education in the United States and who will receive an offer of employment from a U.S. employer in a field related to their degree to more quickly receive their work visas. It's going to be very interesting to see how they break that out or what that looks like. I'm trying to switch this a little bit up here. And then finally, they end by recognizing that it is in our national interest to ensure that individuals who are educated in the U.S. are able to use their skills and education to benefit our country. The administration is taking actions to facilitate the employment visa process for those who graduated from college and have a high-skilled job offer, including DACA recipients and dreamers. Now, again, remember, this takes out a whole group of people who can't afford to go to college, okay? Or they may want to work in the trades area. So we're going to need a lot more clarification of who's going to benefit from this and who will not as we get into the details. So if there's any questions out there, as I mentioned, reach out to us. Let us know. We're going to be doing more. We're going to put out a couple videos on this topic to try to get more details out to you guys. But give us a call. The number's on the screen, and see if there's something that we can do to help you out. If there's no more questions, I want to thank everyone for joining us today, and we look forward to seeing you next month in July when we choose another topic, and we look forward to speaking with you. Finally, if there are U.S. employers out there who are seeking very good immigration support on the employment-based side, we'd be more than happy to introduce ourselves and see how we can help you navigate through the chaotic immigration system. Thank you guys for joining us today. And with all of that, we, from here on Ray Law International, we want to say thank you and have a great Juneteenth day here on June 19th. Thank you and have a good evening.